hold on. Okay. So what I want to talk about, just a little bit about myself and HR3D to give you a sense for who I am and the services that we provide. HR3D has been providing compensation and compliance solutions to the federal contractor community for over 17 years. We provide compensation infrastructure mapping for employees, RFP labor category pricing support, affirmative action plan services, and active OFCCP and DCAA audit preparation support. Our general companies, the sizes of our clients typically are small to mid-tier companies that are not really large enough to have their own compensation and compliance staff in-house. Generally speaking, they're averaged between 100 to about 300 employee range, although our largest client is about 10,000 employees. We really got started in the business as remediation specialists for conciliation agreements, which are the agreements that contractors have to enter into with the auditing agencies once they're found not to be in compliance, and they have a certain period of time in order to be able to get back into compliance. And our solutions generally help those contractors get in compliance within about 30 to 45 days. The other thing that's really unique about our business is that we have an active database of over 29 different national compensation surveys. So we really do have our finger on the pulse of compensation and compliance, and also market pricing surveys. So just a little bit about me. I work 20 years of experience. I've been in HR for the entire period of time. Long background with federal and defense contractors up in the Washington, D.C. area, including orbital sciences, Fairchild Space and Electronics. I currently, with HR3D, I'm responsible for all of the literally dozens of compensation, compliance, and affirmative action plans that I do for our clients, as well as implementations. So with that, I'll move on. What I want to start with is just really quickly the difference between DCAA and OFCCP. James mentioned quickly what DCAA is predominantly concerned with how you pay in relation to the outside market being National Market Pricing Survey. DCAA is primarily concerned that the government is not overpaying for services that they procure for the Department of Defense. OFCCP, on the other hand, is primarily concerned with if you have a government contract, regardless of whether it's a Department of Defense or any federal contract, you have OFCCP requirements, and they're primarily concerned with how you're paying your people internally. What they want to make sure is that you're paying your minorities and your females and your majorities in line with each other, that you're not promoting discriminatory practices in your compensation programs. They're also checking to make sure you've got appropriate policies and procedures in place. But that predominantly is a difference with regard to what organizations are doing and specifically what they're looking for. So I think what I'd like to do is, James, I think this might be a great time to launch the first poll question.
Yeah, let's do that, Jim.
If you have that, if you can send that out.
Was that the one on affirmative action?
Coming at you is, yes. The question coming at you is, when did your company last complete an affirmative action plan? While you're getting the polls for that, I'll go ahead and start with the next slide.
Yeah, we'll give you all about 30 seconds here to respond to the first question, and then we'll show the results. Go ahead, Jim.
Okay. What DCAA auditors look for fall into, generally speaking, three areas. They're looking for established lines of authority from the executive on down. They're looking for a series of internal controls, a definitive flow of authority or for approvals, and audit trails. And they're also looking for some consistency, external consistency. They want to know that you're doing things consistent with labor category rates that you're supporting. the next category, generally speaking, they're going to want to check and make sure you have a formal set of pay structures, bonus plans. If you have a formal merit budgets and procedures in place, they want to make sure that you're also ADA compliant, which is America's Disability Act. And they're looking for establishing policies and procedures as well. Lastly, once they're able to establish all that, the next thing they're going to look for is there evidence that the company is following these directions? Are they administering pay in accordance with programs? And then lastly, they want to make sure that everyone is trained. Jim, do we have results?
We do, Jim.
Results for
oddly enough, it's split right down into thirds. We had a third of our attendees today saying that they have done so within the last 12 months, a third saying it's been over a year, and then a third of them said no, they have never done one of these affirmative action plans.
Okay, well, I would just encourage you, OFCCP has added, and I'll talk about this, OFCCP has added over 200 new auditors between beginning of 2010 and 2011, and they're aggressive. They're being very, very aggressive with the number of audits. So I would certainly encourage you to take a look at that and try to get it into effect as quickly as possible. So what I want to talk about next will be the DCAA compensation audit guidelines. DCAA looks at, when they come in, they look at your compensation, they're going to take a look at what they're paying, and they determine that anything, if your average compensation for a particular grade exceeds 110% of the market, that anything above that 110% is unallowable, and they're going to ask you for reimbursement of those funds. Now, in order to be able to understand that, you have to have market pricing available. You have to be able to understand where you're paying your employees with regard to where they are in the particular market. And obviously, the markets vary from different regions. They'll be lower in Florida, higher in the Washington D.C. area, and very much higher in California. So it's important to have market data that is regionally adjusted. DCAA can and will certainly try to recover all direct charges above 110% of your total compensation. Two things. It's generally not a problem for employees because all the employees that you have, you can average their salaries, and you can usually make sure that you stay under the 110% mark. Where companies run into problems is with their executives, because executives are benchmarked individually, and if you have an executive that's over 110% of the market labor category pricing for that region, then DCAA will come back and ask for the money, ask for funds back as being unallowable. We had about a year ago, we had a contractor that came to us and said that DCAA had sent them a notice that said that they wanted $250,000 back based on 5 years of back charges and 3 executives that had been overpaid by a certain dollar amount. We were able to go in and help them establish, because of our database, help them establish that really wasn't the case. We were able to bring 2 or 3 more surveys to bear to show that the 2 of the executives were not over. The third one was slightly over, and they ended up settling the issue for about $11,000 rather than the $250,000 mark that DCAA had asked the contractor for a reimbursement of. So James, this might be a good time to take a look at polling question number 2. And that question is, does your company use any market survey data to support your RFP labor category pricing? Now that speaks directly to the slides that we're talking here. Do you have reliable survey data, national market pricing survey data, adjusted for your particular region in order to be able to base your rates on and be able to defend your rates? That's the question that we're talking about.
Let me ask you a question while we've got this poll up, Jim. I'll give everyone about 30 seconds here to respond to that. When it says market survey data, I know that we have in the past, when looking at what's a reasonable salary, gone to something like salary.com and trust that they have done, the marketization of reasonableness for rates. Is that an acceptable tool to use?
Well, I think that you'll find if you try to go back to DCAA, and rationalize your salary based on something that you find on the internet, I don't think you're going to find a particularly willing ear. If that is one survey that you're using in conjunction with 2 or 3 other nationally known market pricing surveys, for example, Watson Wyatt or WTPF or Mercer survey, it really has to be a national survey that has some credibility in order to be able to make your analysis a legitimate one.
Okay,
So,
thanks.
Yeah. Very good question, by the way. So,
well, we've got the results to our survey. It looks like about we split down into thirds again. It looks like 2/3 of them of our attendees today say no, that they've not used market survey data, and 1/3 have done so.
Okay, I would just once again encourage you to just do a little bit of exploring in those areas. A little bit of time invested in understanding the requirements and gathering a little bit of data could certainly save you an awful lot of heartache with regard to a DCAA or an OFCCP audit, for that matter, because you'll have to use the market pricing survey data to defend your rates to the government, whether you're defending the rates that you're charging the governments or whether you're defending your rates that you're paying individual employees as not having pay discrepancies. Recent changes in DCAA auditing. So there's a few things here that we should be talking about, and on the next sheet you'll see some more startling information. DCAA is predominantly looking at 2 areas: cost reasonableness. The first area is compensation related. They're going to want to check to make sure that there's not excessive executive compensation. By the way, along those lines, within the last 2 to 3 weeks, there has been, or there will be very shortly, legislation being introduced into Congress to limit the amount of money that a CEO or a CFO can be paid that's chargeable to the federal government to $200,000. That doesn't mean you can't pay them more, but the maximum amount you can charge the federal government for a CEO salary will be limited to $200,000. I think today it's up around $650,000. So it's quite a reduction, assuming that it gets passed, and there's reasonably that it will, because there's a lot of support for it. So the other thing is, so they're looking for excessive executive compensation. They're looking for undocumented bonus plans. If your company paid a bonus plan out last year and you didn't have a plan in place before you did that, they're probably going to come back and tell you that that's not, it was excessive and unallowable, and they're going to ask you for that money back. Lastly, in the area of RFP labor category forward pricing, they're going to be looking for extensive backup documentation to show reasonableness and rationalization for the rates that you're charging in your contracts. Some things that are accounting related fall into the area of more of a recovery mode, where DCAA is going to come in and take a look at either your closed contracts or the contract that you're finished up. They're going to be looking at business development versus marketing costs, project losses, which are not allowable, per diem limits on any travel. They'll be looking closely at those. Also, personal use of cell phones. They're really wanting to dig in and try to recover as much money as they possibly can. So if you've got issues around some of those activities, I would encourage you to start. If you haven't, I would encourage you to start taking a hard look at that and making sure you've got a good solid set of rules in place and that you're looking closely at your cost items. Lastly, insurance expenses on dependents are not chargeable. They are for the employee, but not for the dependent. So it's just a note to keep in mind when you're taking a look at that. I want to just show you now. We're going to shift gears for just a second and start talking about OFCCP. OFCCP right now is probably a much more formidable and more challenging organization for auditing. DCAA has had difficulties in the last 5 or 6 years. They've been underfunded. They've had poor morale. They just have not been at the top of their game with regard to getting out and conducting effective audits. OFCCP, on the other hand, has been relatively stagnant since the 1990s with any audit changes, but in the last 2 years, they have just completely turned all of their auditing rules upside down, and are really going after compensation, predominantly compensation issues. So the announced changes include OFCCP. They rescinded the existing rules around how they're going to view compensation. They added 213 full-time auditors. They've launched a new program called Active Case Enforcement, which basically gives them the ability to be able to just about ask you for anything. There used to be a tipping point test in place that would give them an indication that there may be some discrimination taking place. They've done away with that, and they said under new Active Case Enforcement, we're just going to ask for all of your information, all of your data. And in fact, they also have a portal that's coming, a communications portal, a compensation portal, that starting in February of 2012, where contractors, this will impact about 177,000 contractors. Contractors are going to have to start reporting all of their compensation data to OFCCP for the express purpose of being able to take a look at that data to see if there's any disparity impact with regard to how they're paying females and minorities and white males. So again, I know you're hearing a lot about compensation, but that's really where they're focused. They're expanding the data collection and also really looking very hard for discriminatory pay practices. So let's take a look at the next slide, just to give you some sense for what's happening. In 2008, there were no comp-based settlements for OFCCP. In 2009, there were 2 cases. 2010, 10 out of the 35 were comp-based. In the first 6 months of this year so far, there have been 44 financial settlements, which is a 25% increase in CA, which are conciliation agreements. That's an agreement where OFCCP sends you a letter and they said this was our finding, that this was wrong, you need to get this corrected, and you have to continue giving us reports for the next 18 months, and here's the nature of the reports that we want, and then after the 18 months, if we see everything is fixed, then we can discontinue the reports. And then also in the first 6 months, they've also doubled the financial remedies that they charged for all of 2010 within the first 6 months. So it's a very aggressive agenda. And I think, James, probably a good time to maybe take a look at our last polling question, which is, has your company ever conducted a compensation analysis? It's probably some interesting responses here, I'm sure.
Yep, let's go ahead and launch that. Even though I spelled the word analysis wrong, I apologize. Just respond yes or no, and we'll show the results here.
Okay, so we're starting to get really close here, close to the end. What I wanted to talk a little bit now is how do you get prepared? What do you do? What steps do you take in addition to having the appropriate documents and affirmative action plan in place, and in addition to having market pricing survey data available and an infrastructure to be able to map your employees to be able to defend what you've done to the federal government. Basically, a cohesive compensation compliance strategy is really no longer an option for contractors. You're going to have to be able to demonstrate to the government that you have met all of the questions raised by OFCCP and DCAA auditors. And the only way you're going to be able to do that is by showing them a compliant infrastructure and the fact that it's being used, and the analysis that's done on the back end of that shows that your pay practices are not discriminatory. The best way to prepare, obviously, is to defend your practices with market pricing-based compensation infrastructure. The really good part about using that is that you'll also be able to use the market pricing survey information that you have for your bids and proposals group. I mean, your bids and proposals group is probably going to your HR department and asking for, well, how much does this position pay? Can you give me rates for this particular job, or can you help me understand how we bid this? Because we have a labor category, we need to put a price on it, and they've got to go someplace for the data. So with the market pricing survey data, they can go look up the particular job title, look up the salary ranges, and look up the ranges that they're working in, and have a real good sense very quickly for what is an appropriate rate for this particular job title. The other thing is, as I mentioned, the OFCCP is launching a government web portal to begin collecting all contractor data in February of 2012. This is a system that's being put together by IBM. The system is on time. It's going to be delivered in time for them to be able to start collecting the data. And my biggest concern for contractors that do not have a compliant compensation program in place or do not know what their data says is they're going to report this data to OFCCP through this portal, and OFCCP is going to come back and say to them, okay, well, we have your data, thanks so much for sending it, but guess what, we found that you're paying your white males 30% on average more than your white females or your black females, so therefore we're going to conduct a full investigation. They'll come into your facility, they'll take a look and make the adjustments. They'll figure out how many years your employees have been discriminated against with regard to the pay, and you could end up with back pay for 2, 3, 4 years for any number of employees, for females or males, minority males. And the settlements generally run from $250 to $300 up to $400,000 by the time you pay back pay and also any penalties and damages and interest. So it really does make an awful lot of sense to discover the issues before you send your information in, before the government audits, and then get the corrective actions in place. So I think from my perspective, James, I think that's probably a pretty good high-level overview. And was there results from the last question?
Yeah, actually, about 64% of the folks said no, they had not ever completed a compensation analysis.
Okay. Well, I would strongly encourage you to find someone or to locate a resource somewhere and have somebody help you take a look at your data to help you figure out what you need to do or where you may have some opportunities to be able to make some corrections before you send that into the federal government, because if you don't, you really are setting yourself up for some difficulties. So with that, I think, James, I'd like to open it up, see if there's any questions out there.
Yeah, let's do that, Jim. If you didn't or have not done so already, please go ahead and submit your question using the Questions tab. I've got a couple of questions that have begun to trickle in, Jim, so let's jump right on in. One question came in from Amato. He says, "What, in your experience, Jim, what typically triggers one of these OFCCP audits?" You just mentioned that if you send your data in February and they look at it and it's wrong, that's obviously going to trigger an audit. But just in general, what's a typical trigger that a lot of businesses will stumble over?
Well, OFCCP will tell you their audits are generally generated randomly. That certainly is true, but the bigger issue for contractors now is that OFCCP is rebranding themselves as a worker protection agency. And they've been working with unions, with faith-based organizations, with other organizations to get the word out to employees that if you think you've been discriminated against with regard to your pay, send us the information and we'll take a look at it. So I think we're going to see a lot more. We're going to see a lot more referrals coming for audits, not just from the random selection, but also from other organizations that are cooperating with OFCCP, Department of Labor, IRS, and a few other organizations. And by the way, it also reminds me, not to belabor the point, but if you have contractors on board and they really are not contractors, if if you're hiring them and you maintain control over them and you're the only one that you're the only person that they work for, they're probably not contractors. They probably are employees. And the IRS is, as will EEOC, come down pretty hard on that. The IRS has just issued a safe harbor where if companies now want to declare, well, I've had a contractor for a year, but he's probably actually an employee, now is the time to really think about making that declaration. And I mean, you have to pay the taxes for that, for the year that the individual, however long the individual was actually an employee. But at least you won't be subject to fines. But they're going to really crack down hard on that as well. And by the way, information they collect in February, they're going to want it for employees, for all of your contractors, for all of your temporaries, and all of your day laborers. So there's no escaping. They're collecting the data. They're going to get it one way or another. So if you have that situation, I'd encourage you to get some help to try to get it corrected as quickly as you can.
Oh, that's good information, Jim. Hey, listen, one of your slides was talking about the reasonableness criteria. Melissa chimes in and she says, hey, does that reasonableness criteria apply to all forms of billing, for example, CPFF, time and materials, and so on?
Anytime you have labor charges for a federal contract, they're gonna have an opportunity to come back and challenge you. Now, you wouldn't normally think of on a GSA schedule. You'd think, pretty much that's a flat rate, and really the government knows what the rates are up front, and they're generally the lowest rates they're going to get. The problems that companies run into with GSA schedules, and many of them don't realize this, but their executive salaries are figured into the GSA overhead rates. And if you have executive salaries baked into the rates for your GSA schedule, you need to make sure that you don't have any excessive compensation or excessive compensation for those executives that are layered on top of your labor rates. So that's an area that is a lot of people don't think about because it is GSA related, and you wouldn't normally think, well, why do I need to worry about that? So I hope that answers your question.
Boy, that's great feedback, Jim. Appreciate that. Well, we've run short on time. I promised to have everyone working back productively in 30 minutes, and we're at that time frame. So, but we still have some questions coming through. So here's what I'll do: is we're going to go ahead and cut off the audio, and I'll leave the electronic version up for a few extra minutes and allow you to go ahead and continue to submit those questions, and then Jim will respond to those offline. We want to thank you for your attendance today and for participating. We certainly appreciate you coming on board today and being a part of this presentation. I would encourage you, if you have additional questions for Jim, you can respond to him directly using his contact information, and also send out a follow-up email tomorrow that has links to Jim's website. Actually, it's HR3D's website, and some background material that he's going to be providing, as well as the slides from today, so you'll have some of that reference material in front of you. You may be asking, how does Journyx connect with this? Well, we've been around for about 15 years, and we have some software solutions that help you to be able to track exactly what folks are doing, what they're being paid, when they'll be finished. It's basically a tool that helps you to be able to, if you sync it up with your accounting system, to be basically DCAA compliant. So we certainly help you from the financial side of things and time tracking. So if that's a difficulty you're having, feel free to give us a holler there on the website. I'd also encourage you to visit the website there at journyx.com. We've got a series of webinars like you're attending today from some great speakers just like Jim, who are offering their expertise on different areas of DCAA compliance. We've got a consultant right now giving a presentation on how to acquire and execute on government contracts. We've got another one that is doing one on how to implement a time tracking system to be DCAA compliant. And I've got 4 more folks lined up for November, including Jim. They're going to be presenting some various topics associated with garnering and managing and growing your business using government contracting and being compliant. So would encourage you to take advantage of these experts in this field to educate yourself and grow your business. Again, we want to thank you for taking time out of your schedules to join us today. We hope that this has been helpful, and we hope all your contracting is successful. Have a wonderful day today. Thanks again.